rise. Please be seated. All right, let's go on the record. We are here in open court. It's the court's criminal docket, case 618342, entitled State of Ohio versus George C. Brinkman. Present in court is defendant Mr. Brinkman with his attorneys, Mr. Thomas Conway, Mr. Fernando Mack. Present representing the State of Ohio, the County Prosecutor, Mr. Michael O'Malley, Assistant County Prosecutor Sal Awadala, and Christopher Schroeder. We're set today for sentencing. On a prior date in court, this three-judge panel, after hearing evidence presented by the State of Ohio with respect to the aggravating circumstances and the mitigating factors presented by defense, found this defendant guilty beyond reasonable doubt of the aggravated murders and related counts. We also considered in the sentencing phase the necessary factors with respect to the death penalty, and now we're ready to proceed with the sentencing hearing. Have the victims' representatives speak. We'll start with the State of Ohio.
Thank you, Your Honor. Your Honor, State of Ohio versus George Brinkman, case 618342. Here on June 10, 2017, trust and familiarity turned into treachery, torture, and unspeakable violence when George Brinkman decided to murder Suzanne and her two daughters, Taylor and Kylie. Suzanne, Taylor, and Kylie were brutally murdered by Mr. Brinkman. He killed Suzanne within arm's reach of her two daughters, as well as within sight of her two daughters, and then turned and killed Taylor, and then killed Kylie, leaving Kylie to witness the murders of her mother and her sister. We believe the state has provided sufficient evidence in the first phase that the aggravating circumstances, or second phase that the aggravating circumstances outweigh the mitigating factors, and we again ask that the death sentence be imposed at the appropriate time. This time around, and I believe the panel has made that determination as to each murder, so we should be asking for the death sentence for Suzanne's murder, for Kylie's murder, as well as for Taylor's murder. At this time, Your Honor, if the court will allow and I know the court has made a determination already that the aggravating circumstances do outweigh the mitigating factors, having deliberated on a prior date, but at this time we ask that the panel hear from the father of the two daughters, Taylor and Kylie. That would be Brian Pfeiffer.
Yes. Good morning, sir. Please state your name for the record.
Brian Pfeiffer, P-I-F-E-R. Your Honors, my name's Brian Pfeiffer. I am, and forever will be, Taylor and Kylie's dad. For nearly a year and a half now, I've been attending all of these pretrial hearings, reading all of the motions filed by the defendant, each arguing that he has specific rights. He has a right to representation. He has a right to postpone the trial so his attorneys can be adequately prepared. He has a right to hire an expert witness to argue some form of mitigation. He has a right to not have anyone talk to him while he's in prison in case he says anything he shouldn't say. We even had to hear how he needed a haircut. But today I'm asking you, honorable judges, to be the voices for the rights taken by Mr. George Brinkman Jr. The right of Taylor to finish her last year at Kent State University. The right of Taylor to graduate, to get a job in the fashion industry that she was so passionate about. to get her first apartment, her first car, her first house. Taylor's right to get married, to have children, to celebrate the holidays. Her right to play another game of softball and sing in the car and go to concerts. Kylie's right to become a forensic scientist that she always wanted to be, to finish her education at BGSU, and to get her master's that she had planned on. Her right to go see theater again and see Phantom of the Opera, that was her favorite. To go shopping in Soho again. To get the New York City apartment that she always wanted. The right to make her artwork and send it to me in stages, asking for my feedback. The right to sing with her sister in the car and correct her on the lyrics to the songs. Her right to get married and to have children. And all of our rights to be a part of those things. The rhetoric used by the defense in the entire second half of these proceedings was meant to diminish the impact of the crimes, referring to them as a situation, an event, an incident. That is not accepting responsibility for what you have done. The reality is that George Brinkman Jr. took from all three of them the very right to breathe when he carried out his plan last June. When he brutally murdered Taylor, Kylie, and Suzanne. When he bound them, murdering them one by one. He didn't show any mercy. Yet, he has the audacity to ask this court, you, for mercy on him. They didn't deserve this. That's why today I'm asking you to be the three voices for the three lost. I'm asking you to remember all the testimony that you've heard and all the rights Mr. Brinkman ripped from them, from all of us. In his unsworn statement to the court, he acknowledged that he deserved to be sentenced to death. The simple question before this panel, at least in my simple mind, is this: would the world be a better place without George Brinkman Jr. in it? I believe, as does the whole family, that the resounding answer to that is yes. Thank you.
Thank you, Your Honor. Your Honor, at this time, Your Honor, Suzanne Taylor's mother, Ms. Marsha Taylor, would like to address the panel. Go ahead.
Yes.
And she is going to be brought up to the podium, and Ms. Kennedy from our office, from our victim advocate office, will be reading the statement. Thank you.
Ms. Kennedy, can you state your name for the record, please?
Yes. I'm reading the victim impact statement of Marsha Taylor, spelled M-A-R-C-I-A. She is the mother of Suzanne Taylor, grandmother of Taylor Pfeiffer and Kylie Pfeiffer. Suzanne was a 45-year-old hardworking single mother. Taylor, 21, was a junior at Kent State, and Kylie was only 18 years old and a freshman at Bowling Green State University. All three women were involved in softball and coaching, and they had many, many friends and people who loved them. The defendant took my family away from me and tore my heart out. The manner in which they were killed was extremely violent. It hurts to know that two of the women possibly witnessed the other's murder. Why did the defendant cut Suzanne's hair? What made him go from a friend to a cold-blooded murderer? So many questions go unanswered. I had to be hospitalized because from the day of the murders, my health took a nosedive. I have post-traumatic stress syndrome, major depression, and I'm not able to sleep or eat well. I'm under the care of a psychiatrist. I'll never ever get over it. If I didn't have my son, Ken, there would be no reason to live. I'm heartbroken. In closing, I believe the defendant should get the death penalty. It's only fair that his life be taken, as he cut short the lives of Suzanne, Taylor, and Kylie. Thank you.
Thank you.
Thank you, Your Honor. At this point, the state would just like to highlight and that the events of June 10th, 11th, going to the 12th would have been much worse had it not been for the actions and the involvement of, and the reason we're here today with this result, I believe, is a result of the hard work of the North Royalton Police Department, specifically Detective Skozin and Sergeant Revicki, as well as the assistance and it's really an interagency cooperation here, the assistance of the FBI, Special Agents Andy Earl and Kerry McCaffrey really dug in that first 24, 48 hours to get us to where we're at here. With the assistance from BCI, Justin Soroka, and of course the technical expert assistance from our own Cuyahoga County Medical Examiner's Office and Regional Crime Lab, Dr. Andrea McCollum, Dr. Butt, Kerry Bauscher, Lisa Propesny from the Trace Department. And finally, Your Honor, I'd like to thank my colleagues, Dan Cleary, Kevin Brinkman, Chris Schroeder, as well as our county prosecutor for giving us the resources to allow us to pursue this case. Thank you very much.
All right, we have the defendant, Mr. Conlon, Mr. Mack.
Please support. Mr. Brinkman is not going to speak this morning. And with all due respect, we're asking the court to reconsider your sentence and impose a sentence of life without the possibility of parole. For all the reasons previously stated during our closing arguments and mitigation phase, we still believe that the aggravating circumstances do not outweigh the mitigating factors presented to this court. We just wanted to highlight, we ask that you consider his acceptance of responsibility early on in this case. And throughout all stages of the case, he always demonstrated the willingness to enter a plea of guilty without the possibility of parole. And the fact that he did enter a plea of guilty and did not drag the family through a trial should weigh heavily before this court. His genuine remorse articulated through the interviews, letters, and his unsworn statement. We ask the court to consider his lack of violent history, his limited criminal history. We also ask you to consider the abusive relationship at the hands of his father that was testified by our witnesses. And we ask the court to consider the severe depression stemming from the loss of his mother and his brother. And went through the state's sentencing memorandum. I know that it was argued that that's a weak factor, but we beg to differ. It's a factor that should be weighed heavily. People take their own lives every day in this country based on severe depression, and it can influence behavior. But again, there's no excuse for Mr. Brinkman's behavior, and it's not to be looked upon as an excuse. We also ask the court to consider what he was going through physically, the appearance that was conveyed by witnesses of his lost weight, his diabetes, and how when he didn't take his medication that can impact his state of mind and his behavior. And based on his history and his characteristics, we know that his behavior demonstrated, as long as it was on this day, was aberrant based on his history and his characteristics. And we are respectfully asking the court to consider what Mr. Aiken had to say in terms of whether or not he poses a risk a future risk to inmates and staff where he knows he's going to have to be for a long time. We are respectfully asking the court to impose a sentence of life without the possibility of parole. We also ask the court to, on the underlying offenses, to run those offenses concurrent with one another based on the purposes and principles of sentencing. Consecutive sentences are unwarranted and unreasonable under these circumstances, especially if the court still chooses to impose a sentence of death, 3 separate death verdicts. And that's respectfully our request. Thank you.
Mr. Brinkman, is there anything you'd like to tell the court?
No, sir.
Anything further from the state?
No, Your Honor, thank you very much.
There is an agreement between the parties with respect to allied offenses, is that correct?
There is, Your Honor. We agree with what's articulated in the memorandum.
So count 1, aggravated murder, the victim being Suzanne Taylor, and count 2, aggravated murder, are allied and merged, is that correct, Mr. Schroeder?
Yes, Your Honor.
The state elects,
We will have to proceed to sentencing on count 1.
and with respect to count 3 and count 4, aggravated murder, with respect to the victim Taylor Lynn Pfeiffer,
Those will both merge as well, Your Honor, and we will like to proceed on count 3.
and counts 5 and 6, aggravated murder, with respect to the victim Kylie Elizabeth Pfeiffer.
Those 2 counts will merge as well, Your Honors, and we will like to proceed on count 5.
Any other issues of allied offenses?
No, Your Honor.
Is there any objection to that from the defense?
No, Your Honor.
First of all, on behalf of this panel, we'd like to extend our sincere condolences to the family members who are here, who have been present and active throughout this entire very long and as I heard, often frustrating process. Our laws are made to protect the rights of those accused, and we have sworn an oath, everyone, the attorneys, the judges, to protect those rights. And that's often cold comfort to the victims' family members who have lost a member of their family forever. And all those efforts defense makes protecting the rights of the defendant just fall on deaf ears and are often upsetting to the family members. We understand that. We appreciate how you've acted throughout these proceedings, and we understand your feelings. And it's every case in which an innocent person loses their life is always senseless. There's never any sense to it. And there will never be any sense found in it or any good reason for it. And all the law can do is what the legislature has allowed us to do. And we have considered all these factors. We have made specific findings beyond a reasonable doubt that this defendant is the principal offender in the aggravated murder, that the aggravated circumstances outweigh the mitigating factors. And pursuant to the revised code section 2929.03, we do hereby impose the death penalty in count 1, count 3, and count 5 for those aggravated murders. No sentence will be imposed in count 2, 4, or 6 pursuant to the allied offenses agreed to by the parties. The remaining underlying allegations, the court has considered all the principles and purposes of felony sentencing, all the appropriate recidivism and sentencing measures as required by our sentencing statutes. Also, I have considered specifically whether or not consecutive prison sentences are appropriate. Hereby, I do find that the facts and circumstances surrounding these brutal murders carried out with pre-calculation and design, and the underlying offenses, they're part and parcel of this plan, require consecutive sentences. It is necessary to protect our community and to punish this defendant. Consecutive sentences are not disproportionate to the harm that was caused in this matter. That the harm is so great or unusual, a single term does not adequately reflect the seriousness of this defendant's conduct. So the court's going to impose the following sentences. In count 7, aggravated burglary, it's a felony of the first degree, 11 years in a correctional institution. In count 8, it's kidnapping. With respect to victim Suzanne Taylor, it's a felony of the first degree, 11 years in Marine Correctional Institution. In count 11, which is gross abuse of a corpus, with respect to victim Suzanne Taylor, 12 months in Marine Correctional Institution, that's a felony of the fifth degree. In count 9, kidnapping, with respect to victim Taylor Lynn Pfeiffer, 11 years in Marine Correctional Institution for that felony of the first degree. In count 12, gross abuse of a corpse, with respect to victim Taylor Lynn Pfeiffer, 12 months in Marine Correctional Institution. In count 10, kidnapping, with respect to victim Kylie Elizabeth Pfeiffer, felony of the first degree, 11 years in the Marine Correctional Institution. In count 13, gross abuse of a corpse, with respect to victim Kylie Elizabeth Pfeiffer, 12 months in the Marine Correctional Institution. Sentence will run consecutive to each other. Count 7, consecutive to 8, 9, 10, 11, 12, and 13. 47 years in Marine Correctional Institution. Pursuant to our statutory duties as well, with respect to this death sentence imposed, these underlying sentences are consecutive as well. Post-release control also must be addressed on the underlying counts. Post-release control is a mandatory period of 5 years for the felonies of the first degree. If you are ever released, you will be supervised for 5 years. It's mandatory. On post-release control, you must follow the rules of the parole authority. If you are ever supervised on post-release control, if you fail to follow the parole authority's rules, they have the power to send you back to prison for a total up to 50% of this original sentence. Any violation of the parole authority's rules could result in a residential sanction, which could include a new prison term up to 9 months. Those rules on post-release control will require you to report to a parole officer. If you ever fail to report, the parole authority may punish you by sending you back to prison. You also could be indicted on a separate felony called escape, which means that judge assigned to that new indictment can also punish you with time in prison, even if the parole authority also punish you with a prison term. That's also true of any other felony you might commit on post-release control. Parole authority can punish you for that felony, and the court assigns the new indictment can also punish you. If you are convicted of a felony when you're on post-release control, the sentencing judge will have an option to impose a consecutive prison term for the amount of time remaining on post-release control, or 12 months, whichever is greater. You do have a right, appeal as a right with respect to these matters. We had previously found the defendant indigent. Would you like us to appoint appellate counsel as well? Please, Your Honor. Our specific findings will be journalized in a written opinion and filed with the clerk. The entire record will be transmitted to the clerk of courts and preserved for appeal. This is defense asking for jail time credit.
Yes, Your Honor.
Is that an issue? Calculated in days?
We have not, sir. So we will.
Could I have one moment, Your Honor? I'll do that now.
We're also opposing Court costs, responsible for court costs, this matter, you need to require to do community work service therefore as well. Court will assign an attorney, provide a transcript at the state's expense for the appeal.
May we approach her?
Yeah. All right, also for the record, post-release control, also is discretionary with respect to the felonies of the 5th degree, so the record is absolutely clear if that ever becomes an issue. 3 years discretionary post-release control on the F5s, mandatory 5 years post-release control on the F1s. State of Ohio also has final request.
Your Honor, would request since the Mr. Brinkman has been sentenced to death, and upon the filing of the opinion, that an execution date be set by the court within the year. We understand that there's appeals that will stay that, but I believe that that's a practice, if not required by the statute, that an execution date be set by this trial court. Thank you.
All right. Anything from the defense?
Your Honor, may we take a moment, please? Your Honor, may we approach?
Yes.
Your Honor, on behalf of Mr. Brinkman, like the court, you advise him of his appellate rights to these proceedings. We have also advised him of his rights and the pros and cons of appealing this matter. And Mr. Brinkman has made it clear to us, as he has early on in this case, that he does not wish to appeal your decision.
Mr. Brinkman, is that correct?
That is a true statement, sir.
Have you had enough opportunity to talk to your attorneys about what the appeal entails and how it will proceed?
Yes, sir.
Do you have any questions about that for this panel?
No, sir.
Pursuant to our statutory duty at this point, and having considered what defendant's wishes are, the court is going to appoint appellate counsel so that if there is any possibility of this defendant wishing to pursue specific issues that may occur to a counsel, we will appoint the State Public Defender's Office and another attorney with respect to an appeal. Also, the State of Ohio has a request as well for the sentencing date.
Yes, Your Honor.
All right. Considering that the sentence is not final judgment until our opinion has been filed with the clerk's office, I'll set the execution date for January the 15th, 2020. Should be 1 year from when approximately the sentencing memorandum and opinion would have been filed. Is there anything else for the record from the State of Ohio?
Two things very briefly, Judge. Number one, from the date of the defendant's arrest, I believe he is entitled to 564 days of jail time credit, so we'd ask the court to award him that amount. And number two, there was one consecutive sentencing finding that I believe the court did not make, and that was that consecutive sentences are not disproportionate to the danger the offender poses to the public, so we just asked the court to make that finding as well.
All right. If I didn't say that, I thought I did indicate that, that the consecutive sentences aren't just proportionate to what happened. It's